Good evening, everybody, and thank you for joining us tonight for our ISP Wednesday Wisdom webinar. This is our new series for HR professionals, so I hope that you enjoy it and that we see you at the next one. But I'm absolutely delighted this evening to introduce Alice Reeves. Alice is an employment partner at VWV, one of the leading law firms who work with a lot of people in the education sector, and she is going to give us an update on employment law. It's quite a hard task to do that in 45 minutes. It could be a whole day course, if not more. So Alice has very kindly focused on the areas that independent schools in particular perhaps need to be mindful of or aware of, but she's also very welcome to any questions. So feel free to put it in the chat or raise your hand. But without further ado, I will hand over to you, Alice. Thank you.
Great, thanks very much, and nice to see everybody. Yes, well, there's an awful lot going on in employment law at the moment. So an update is it's an action-packed one, and people who know me will know that I always I go at quite a pace, so I hope that's okay. There's quite a lot of information on the slides. I'm not proposing to talk in detail to all of them, but I'm really happy to share the slides so you'll all be able to take them away and have the more detailed information. But today is really designed as a heads up of things that are happening. And I've broken it really into, I suppose, four main topics. Some changes that are happening in April, so next month, so some priority things, and first and foremost in those really is the introduction to neonatal care and leave. So that's happening on the 6th of April. So I've got a little bit of information about that to explain how that's going to work. We saw a change in October around sexual harassment, so I just wanted to, well, bring that to your attention if you weren't aware of it, but just have a quick look at where we are now 6 months on. And then the big topic of the day really for any employment lawyer is the Employment Rights Bill. And so I haven't picked out, there are sort of 28 at least changes being introduced as the Employment Rights Bill. So you'll be pleased I'm not covering all of them, but I've picked out a few of the ones that I think are of most significance, and certainly to independent schools. So I've included that. There is a lot to get through, but please do stop me if anything's at all unclear, or if you've got any questions, or if you've got any comments, or there's anything you want to add. So just starting with the things that are happening next month, the first one I just wanted to mention was the increase to the national minimum wage. I'm not going to read the slide, but from April there's an increase in all the rates. The most significant one perhaps is the middle one listed there on the slide, that there's currently a rate for 18 to 20-year-olds, but the government are committed to removing that so that actually anyone 18 or over will be entitled to receive the national minimum wage or the national living wage as it's rebranded. And so you'll see that for this year there's been a really big step up in that middle group category because it's being phased out, so that ultimately everybody 18 or above will receive the higher one, the national living wage, which is going up to £12.21 from this April. So we always see the national living wage causing some difficulties with schools because it comes in from the 1st of April, and in fact that's a funny time for pay awards for most schools that usually work their budgetary years from September. So it's important that you do, or someone does an analysis to make sure you've swept up anyone who might fall below that hourly rate to ensure that you're compliant. As well as the increase to national living wage, we've seen the increase to employer national insurance. That was a bit of a came from left field in the budget and took most people by surprise. It's going up from 13.8% to 15%. That's probably already on your radar. Quite significantly as well, there's a threshold, a lower earnings limit before national insurance is payable by employers. And that's going down quite significantly from £9,100 per annum to £5,000. And actually, we've seen amongst school clients that I work with that that's having a really significant impact. And I think actually lots of schools do engage low earners because there are lots of people who work part-time, perhaps doing lunchtime supervision or a bit of grounds work or variable hour contracts, which means that they fall below the threshold historically, and now they're being swept up and caught in the national insurance. So the national insurance bill for most schools is going up significantly in April. And so although it's sort of a fairly dry information point, I think the implication of the cost of the increase to the living wage and the changes to national insurance, we've seen them driving sort of strategic staffing changes. So schools are looking at their staffing cost base, and we're sadly in a period where schools are undertaking quite a lot of redundancies or looking at restructurings or other ways of making efficiencies to reduce their overall staffing overhead. The one bit of statutory change that we're seeing from April is the introduction of the neonatal care leave and pay regulations. These have been bouncing around for ages. The previous government actually committed to introducing these, and we didn't know what would happen to them, and they were sort of left on the back burner when they were talking through the Labour Party manifesto and then their and the Employment Rights Bill, and then suddenly we've seen sets of regulations that mean this is coming into force. So this will apply for babies born on or after the 6th of April this year. So you do need to make sure that you've got a policy that reflects this. It's probably going to be one of those rights that isn't used very often and isn't very common, but you just need to be aware that it does exist for the situations when it will apply. We are awaiting some more detailed government guidance, and there are quite a lot of details in relating to it, but just to sort of run you through them. Essentially, this provides parents of children who go into neonatal care with the right to some extra leave and pay. So neonatal care is mainly that they're hospitalised within the first 28 days of their birth for a period of 7 continuous days or more. So it's intended to capture those babies often who are born prematurely and need to go into neonatal care in hospital or have some problems on birth, and so going to neonatal care. And the idea behind it is that for those parents that for fathers, often the current paternity regime is pretty limited, and so they were using their holiday or having to get some sort of unpaid leave in order to continue to support the mother or take time off after the baby was born. And for mums, generally, if they were on maternity leave, if a baby was in neonatal care for a long time, it eroded the time off with the baby at home. So it's intended to add to that. So it gives parents the right to this extra leave if their child falls within that category, and they can have up to a maximum of 12 weeks leave. And that's based on however many weeks they spend in neonatal care. So 1 week in neonatal care, 1 week neonatal leave, up to a maximum of 12 weeks. And it applies, the leave right applies to all employees from day 1 of their employment, but it is also accompanied by a right to pay, and that requires some qualifying service. And I'm going to come on to that just shortly. So essentially, the right to leave it accrues in 2 ways. There's a tier 1 leave and tier 2 leave, and tier 1 can be taken within 7 days of the neonatal care happening. So it's an initial right. It probably will be used for fathers or partners using the neonatal leave in that way. Then there's a tier 2 right, and that will probably be for where people want to use the neonatal leave tagged on to the other end of their leave. So if they're already on paternity leave or maternity leave, they will add the neonatal leave on to the end. So just to give you some examples of what that means in practice. So if a baby is born and the baby is admitted to neonatal care shortly after their birth, the woman's maternity leave is triggered, and that can't be deferred, so it automatically triggers their maternity leave. But they continue to accrue the neonatal leave for each week that their baby is in neonatal care. They give notice, and then they can say they have 2 weeks in neonatal care. They can then add that on to the end of their maternity leave. So at the moment they have 52 weeks paid maternity leave. It would mean that they'd have 52 weeks maternity leave, and then they could add on the 2 weeks neonatal leave at the end of that. But if you're the father in that scenario, actually, if the dad had taken 1 week's paternity leave, he could then add the neonatal care immediately on to that. So he could take it at that point in time, or he could break it up and take 1 week then immediately after, and then take the 2nd week later on. as a tier 2 leave. So so it's quite complicated, but in practice, hopefully it'll be relatively straightforward in terms of what the rights are. In terms of the right to pay, it's similar to maternity pay and paid paternity, that if you've accrued 26 weeks service before taking the leave, then you're essentially entitled to neonatal pay during that neonatal leave. And again, that's at the flat rate that you'll be familiar with. Either the statutory rate that's the same as maternity, or 90% of earnings. In terms of giving notice, if it's tier 1 leave, so when the baby is first in hospital, actually you don't need to give really significant notice at all. You can just tell your employer that the day before, and there's even an exemption for if that's not reasonably practicable. So you can anticipate fathers in particular going into hospital in a state of emergency and then telling their employer, and that will be absolutely fine. If they want to receive the pay, they do need to put it in writing, and they do need to confirm that they are taking the leave for the purpose of caring for the baby. If it's the later leave, the sort of tier 2 leave, which is tagged on or taken at a later date, not in that immediate period, then there's a more formal notice requirement. And if they want to take 1 week, you've got to give 15 days notice. And if you want to take 2 or more weeks, then you've got to give 28 days notice before that leave's due to start. So I don't think many of us will remember all the details of that. It's my day job, and I'm sure they won't be at the forefront of my mind, but it's just important setting them out in a policy and making people aware of it, so that actually if and when you've got members of staff whose children do need hospital care, or it can be outplacement as long as it is very formal neonatal care, then in the first days of their lives, then they've got those additional rights, and you know where to find them. I don't know if anyone's got any questions on that, otherwise I'm going to move swiftly on.
Don't seem to be any, Alice.
Great. So the next thing I wanted to talk about before we get into the Employment Rights Bill is just to mention the new duties, the new proactive duty on employers to prevent sexual harassment in the workplace. These came into effect in October 2024. So it's important that you are aware of them and perhaps have done something about them in your organisation. Just to set the scene before we talk about the new duty, essentially this applies only in relation to sexual harassment, and that's covered and protected under the Equality Act 2010. And harassment is where a person engages in unwanted conduct of a sexual nature, and that conduct has the purpose or effect, so it doesn't have to have the aim if it has the effect of violating the other person's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment for them. So the important thing is that actually, well, it could be sexual harassment if it's an intentional act, but it could be if it's unintentional, but it has that impact or the effect on the victim, if it's reasonable for them to hold that view. So it's often people ask when things are, that debate about when things are acceptable or banter, and actually it's important that it's in the eye of the person who's being subjected to it. So we already had a framework that protected employees from being subjected to sexual harassment against each other. So if an employee felt that they'd been harassed, they could bring a claim against that employee and against the employer, potentially for not stopping it. But since October, there is a new requirement that bolts on, is supplementary to those existing causes of action and claims that an individual may have, and that is that it means that an employer, so all employers have got a new duty to take reasonable steps to prevent sexual harassment in the course of employment. So it's a new proactive duty. What that means is that an employee who's subject to harassment can bring a claim against the employee, against their employer for being liable for their employee, but also they can add on this new one to say, and you, school, you did not comply with your duty to prevent sexual harassment, and so that has caused this. And if they're successful, that increases the amount of compensation as well as the school being liable. We do have some detailed guidance from the Equality and Human Rights Commission, and there's a really useful 8-step guide. So if if you're interested in this area, that's a really useful reference point in terms of what that duty means. There has been quite a bit of criticism that this doesn't go far enough, and in fact, we'll look at the changes that the Labour government are proposing and saying, well, hold on, there was already some form of duty, and you could be liable if you hadn't taken reasonable steps. What does this mean? Well, it is a proactive duty, and the intention behind it is that that previously you had to try and stop your employees from harassing the others, and that might be from telling them about what conduct was acceptable or not, and making sure that they were aware of your policies and taking action when it happened. And that was one thing. But this is about creating a culture and an environment so that no employee experiences sexual harassment in their work place and in their work. So it's a safe environment for every individual. So it's about positive cultures and changing from the top. So although it's perhaps a nuanced difference, it is an important difference as well. So school will be able to defend themselves if they've taken reasonable steps, and the 8-step guide drills into the 8 kind of things that you should be doing in order to demonstrate that you fulfilled your obligations under the Act. The first is that you've got to have up-to-date policies, so do check that you've got an up-to-date policy on harassment or anti-harassment in the workplace. Training is really important, and you'll need to have tiered training so that all your staff are aware of the conduct that's acceptable, and what to do if they're subject to behaviour that they don't consider to be acceptable in the workplace. And managers have more detailed training so they understand how to deal with things if they're raised with them, and how to ensure that they're taken seriously as well. Make everybody in the organisation aware of the importance of zero tolerance towards behaviour that is unacceptable. Think about staff engagement. It's worth looking at staff surveys. I know they're very popular, but asking staff actually is interesting if they've ever been subjected to harassment, and if they have, why did they raise it? If not, why not? And are they aware of how to raise it? And once you've got that sort of information, you can then tackle any problems with the effectiveness of that, and can track it as well in the future to show the effectiveness of these steps that you're taking. It's important that people are able to report it, and that it's effectively dealt with when they do report it, and they feel that they feel confident in that. And there's some really interesting statistics about how few people do report being subjected to harassment at work, and most of the time that's because they don't have any faith that there is going to be anything done about it, or they're worried about the reprisals that they'll be subjected to as a result. There's a lot of emphasis on number 6 on this list is about risk assessment. You'll all be familiar with risk assessment in different contexts, but actually that is about looking at your organisation. And in schools, there's lots of interesting areas where there are perhaps higher risks. So where there are some social events, where people are staying overnight, perhaps, on a DFA expedition, or drama trips, music trips, and so the high risk areas, and looking at whether you can do anything to manage or mitigate the risks in those areas. As well as this, number 7, thinking about third-party harassment, and what that means is not just controlling your employees and how they interact with one another, but thinking about all the other people that touch on your community. You'll have visitors, you'll have contractors doing some forms of work, you'll have alumni, and it's all of those people that you will need to think about. And it's becoming more common to have some sort of aims or ethos or code of conduct, and making everybody aware of the standards of behaviour that they're expected to adhere to if they're part of the school community, and taking effective action if they are not. And finally, this came in October, but it's an ongoing obligation, so it doesn't matter if you haven't done anything yet, but it is important that it's added to your agenda and thinking about the things to do, and that you do that on an annual or more regular basis to monitor the things that you've got in place, and then evaluate how effective they've been. And if you do have people raising grievances, or the parental complaints, or other issues or exit interviews where things come to light where there has been harassment, actually take stock and think, well, how did that arise? Can we do anything to tweak our policies, procedures, other steps to manage that in the future and prevent it happening again? Just before I move off this topic, and it will segue in nicely to the Employment Rights Bill, This law came in October, but it is already being mooted as a subject for change. It had a really difficult journey through the parliamentary process, and actually it was watered down really significantly by the House of Lords. And the Labour government have said that they are committed to strengthening it again. So the new duty is to take reasonable steps to prevent harassment in the workplace. Labour have said they want to take all reasonable steps. What's in a word, but actually it's quite a significant word, because all reasonable steps is quite a far-reaching obligation. It definitely means it's worth taking reasonable steps now and putting some things in place so that you're in a stronger place to supplement them if there's an even stronger duty in future. There'll be an express obligation to protect your employees from third-party harassment. So although I highlighted that as a risk area and one you need to think about, at the moment it's not expressly covered, but it's likely that it will be expressly covered, and that's an area that's quite challenging for schools when you think about all those different relationships and parents and pupils. And so you'll need to start to work on that and think about your documents. And they are also thinking about ensuring that people who sign up to confidentiality, non-disclosure agreements, where they've been subject to harassment, that will be carved out, so they won't be able to sign up to that. You won't be able to prevent somebody sharing their experiences of harassment in the workplace, and that's about tracking patterns and ensuring that they can be dealt with appropriately. So although we've already seen a fairly significant change, there's more on the horizon and it's not going away. And it's definitely something that should be on your radar. I'm now going to move, conscious, we've got covering a lot of ground. I'm going to move on to the Employment Rights Bill, which is the most significant piece of employment legislation we've seen for a very long time, or maybe since 1996. Many of my team have not worked under a Labour government, and the proposals represent a really significant shift in rights of employees. I'm going, as I say, I picked out some of the main ones that I thought were worth drawing to your attention, and many of them you may already be aware of. The first one I wanted to mention is that at the moment, employees are not protected from unfair dismissal until they have 2 years qualifying service. So you've got a lot of latitude at the moment to deal with employees who aren't working out within that period of time. That is going to be removed, and employees will have protection from day one when they join you. There will be provision for an initial period of employment. I think most of us call that a probationary period, and I think it's going to be sort of one and the same thing. That's likely to be 9 months, and so during that 9-month period, there will be a light touch process during which you will be able to bring employees' employment to an end. That process is likely, we've not got any detail yet, to be inviting them to a meeting at which they've got the right to be accompanied by a colleague or trade union rep, giving them notice following that meeting, and potentially the right of appeal as well. There's also talk of giving them a right to bring a claim for unfair dismissal, for example, if you haven't followed that process properly, but capping it so it's more limited compensation during that 9-month period. But after that 9-month period, they will have full protection from employment law, and you will need to follow your full capability or disciplinary process. It's also important to note that that light touch process won't apply if the reason for bringing their employment to an end is about your changing needs or other organisational reasons. So actually, you can't just make them redundant within the first 2 years, as many employers are doing at the moment. But in fact, they will be like any other member of staff. They will have protection. And you'll need to treat them exactly the same way. So there are a number of things that you can be doing to get ready for this change. The management of probationary periods is really important, and my experience is that it's pretty sporadic in schools. So do think about, have you got a policy? You don't need a probationary policy, and often it may be better not to have one, but if you have, make sure you understand it and it works for you. But most importantly, who is managing people on probation? Who's diarising when that period comes up? How many meetings are there? Are we giving effective feedback to individuals during that time? And making sure that if it isn't working out, that we're acting on that within the period and not just waiting for it to lapse, because that's already quite problematic, but it will be even more so once this change is in place. So thinking about effective management of probationary periods is really important. But also, once that initial period of employment or the probationary period is over, then everybody will be protected from unfair dismissal, and you will need to establish that you've followed a full capability process if they're underperforming. So again, it's quite hard, and people in schools often don't like managing performance, but it will be really important to do that properly and effectively. So again, thinking about training for line managers to ensure they've got the confidence and they understand how to performance manage effectively will be really important. And finally, I think it's probably just also worth thinking about recruitment, because the protection applies when people start in employment. And so making sure that you are rigorous in your recruitment process, making sure that you actually ask some difficult questions, that you carefully review the references, and if you're not satisfied, that you follow them up. And I know the recruitment market is really difficult, but actually you need to be satisfied that they are good recruits and you're happy that somebody is the right person for the job, because they are going to have much more far-ranging employment rights than they have had previously if it doesn't work out. The next one, just keep an eye on the time. The next change I wanted to mention that is really significant, it relates to 0-hour workers. And so this is people who are not guaranteed any number of hours or just a very low number of hours. So they're basically paid as and when needed. So in schools, you've got lots of people probably who fall in this category. Exam invigilators are a really common one. Some other sort of sports coaches, some hospitality staff and others. So make sure to start with that you've got a handle on how many staff you have got and which categories of staff you've got who are engaged in this way. And the Labour government essentially started by saying that they were going to prohibit the use of 0-hour contracts entirely. They moved backwards from that position when employers explained that they really needed some form of flexibility, and actually some workers, employees, said that they needed flexibility too. So now actually it's about banning exploitative 0-hour or low-hour contracts and giving those individuals some additional rights. So the main right that these individuals will have is that if they are working regularly over a reference period, they will then be able to ask for a guaranteed hour contract. So they'll be able to say, I've worked, regularly 10 hours a week for the last 12 weeks. I would like a contract that is a guaranteed part-time 10-hour contract. And not only will it be the hours of work, but it will be the days and times of work as well. So that's a really significant shift to mean that you will no longer have flexibility to vary their hours dependent on need. There are some exemptions, particularly where they are working to cover a short-term need or seasonal work. Obviously thinking of fruit pickers, but for us it might be tennis coaches or exam invigilators or people who are coming to do a short-term bit. And so you will be able to engage people on short-term contracts for those purposes. But other than that, they will have these rights, and it will apply not only to people who are employed or workers with you, but also the consultation has just finished to say this will apply to agency workers as well. So it won't be an easy way out to use agency workers to fulfill varying needs. Sorry. It's important that they not only have these rights, but there's a proactive obligation on employers to let them know. So actually, I think quite a lot of people thought, goodness, this is a real headache. Perhaps we'll get away with just carrying on as we are. But once this is in, you will need to tell those people who engage on the contracts that they have these rights and they can exercise them. And as well as the right to ask for guaranteed hours, there are some other changes that probably have less effect in a school context, but are designed to protect individuals as well, that they have to have reasonable notice of shifts. If they're not given reasonable notice, they can have compensation for late changes or cancellation of those shifts as well. So there's a range of protections that are coming in. It's one of the areas that's most complicated, I think, in the Employment Rights Bill. it will definitely affect schools, but as I say, I think the starting point is to make sure that you know how you engage staff. And actually, if people have been working lots of hours or on a really regular basis, change the basis on which they're contracted now, put them on short-term or guaranteed part-time contracts, and then you can minimise the group of people who are likely to be affected by this. And then when the changes come in, we'll have more detail, and you'll be able to think about how that may affect you. The next significant change I wanted to mention is around flexible working. And in some ways, the law isn't fundamentally changing, but again, Labour wanted to make flexible working the default. And actually, we've already seen a bit of the impact of that, and perhaps just shifting the balance of where flexible working sits in the organisation. So at the moment, you're probably aware that individuals have got the right to request from day one. They've got the right to request a flexible working pattern. So to reduce their working hours, reduce the to reduce their working hours, to change their times or patterns of work, so to start late, or their place of work, so to work from home, for example. And you have to go through a process, and you can reject that request on one of 8 prescribed business grounds. That is fundamentally not changing. So that process that you're used to, the ability to reject a request, is all remaining in place. But the critical difference is that you will now not only have to point to a ground and show that that exists, but that your reliance on that ground is a reasonable one. And that's objectively reasonable, which will ultimately be tested by an employment tribunal. And so we will see employees challenging the reasonableness of those decisions, and they will be able to bring a claim if they think you've exercised that decision unreasonably. And so I deal with flexible working requests all the time for schools, and they often say, well, we can't accommodate that because of the needs of the timetable, and we duly write that in the letter. But actually, you will need to demonstrate that that really is the case, and that's going to have an impact on the quality of provision or continuity, and you'll need to explain why that is and why it can't be shuffled around in another way, and document that all at the time, so that if it is subject to later scrutiny, you can demonstrate and easily explain why that ground was legitimate and why it was reasonable to rely on it in the circumstances. The next change I wanted to mention, making good progress, and please do shout out if you've got any questions, otherwise I'm happy to take them all at the end. The next change I wanted to mention is about fire and rehire. You may be familiar with this. Employment lawyers call it termination and re-engagement, by which you're bringing one contract to an end and offering re-engagement on new terms and conditions. This is something that had been a very well established practice and was used commonly where the terms and conditions that were in place perhaps were old and didn't meet the new needs of an organisation, but it got a very bad name and a bad reputation during COVID, where some big employers, Centrica in particular and British Airways, tried to essentially dismiss their current workforces and re-engage them on lower terms and conditions, so lower pay or different shift patterns as well. So at the moment, the current position is that that still remains. Termination to engage people on new terms and conditions is a lawful reason to bring their employment to an end, and that's a lawful thing to do. Schools were seeing it commonly, perhaps where they're trying to change pension arrangements in the TPS, something that I'm doing an awful lot of, and that is lawful, but there is a code of practice that applies that has statutory effect, that the Conservative government brought in, having consulted and got advice and guidance from ACAS. So that essentially explains the process that needs to be followed, and that it must be a last resort, and that you must explore all other alternatives first. So that's the current position, and that's the position as is at the moment. But under the Employment Rights Bill, any dismissal, which is with the intention of then re-engaging somebody on different terms, or bringing somebody else in on different terms, will be automatically unfair. So it will be an automatically unfair dismissal. That will have really quite a significant impact. It will mean that employers won't be able to go through these processes and terminate contracts and re-engage. They will need to either try and agree with people. I mean, that's the first route at the moment now already, but they'll have to try and agree. They might have to incentivize agreement, or they might have to look at what's already within their existing terms and conditions and other flexibilities within that. And we may see employers looking at their contracts and making sure they're drafted flexibly or broadly as possible to capture some changes as well. My next, and I think it might be my last little section, relates to the rights of trade unions, and these are being quite significantly promoted by the Employment Rights Bill. So the new bill gives trade union officials from certified unions the right to access employees. That's actually, it was originally physical access, so access to premises, but in fact the latest amendment that's just been put through also talks about digital access, so the right to access by email, and it's an access to recruit workers, to advise them, to help organise, and sometimes carry out collective bargaining on their behalf. So as an employer, as a school, you will have to grant unions the right to access, to come onto site, to speak to members of staff about that, about all of those things, and to get advice and about being a member of a trade union. So that's culturally quite different than what then applies for most schools at the moment, and this applies whether or not the union are recognised, but it's likely that if it leads to recognition, there will be some sort of document already in place that gives them access in certain circumstances as well. If you as an employer say we're not going to allow access, then the trade union can apply to what's called the Central Arbitration Committee, and they will determine that they've got the right to access and set out an access agreement as well. So there's no doubt that trade unions will use that to try and ensure that they've got access to employees. As well as that increased sort of profile in the workplace, there will be a new requirement that in individual contracts of employment as an employer, you include the fact that workers have got the right to join a trade union. So that's an express contractual right. Unions are here to stay. They are going to be, we're already seeing very, very active union representation in workforces, and of course most individuals are members of unions, which is great to seek advice if they are subject to any allegations or need their support with any process. But it's important for schools that you do understand the relationship that you've got with your trade unions, and you look at building strong relationships with trade union representatives, so you working collaboratively as far as possible. And that probably brings us to when things go wrong and industrial action. So currently, if staff are unhappy and there's a dispute with their employer about something relating to their employment, if that's supported by the trade union, they can ballot to strike. And the Conservative government spent many years trying to make that more difficult. They weren't very successful, it's fair to say. But actually, the Labour government are basically unpicking all of the requirements that they put in place to make it more difficult. So it will be easier for trade unions to organise industrial action. So the first is about the thresholds for when there's support for industrial action. So at the moment, there's a sort of two-faceted test that basically you've got to have a turnout of at least 50% of those entitled to vote. So let's say there's 100 people affected by the trade dispute. At least 50 of those would have to turn out, and then the vote would be passed by the majority. So 26 if 50 turned out, but if 80 turned out, 41. It's needed. So you've got both those tests, and the intention behind that is that you know, if there's an apathy or people are not interested and so don't turn out, it doesn't pass that threshold. The proposal under the bill is that turnout threshold will be removed, so it will just be passed by a simple majority. I think we will see that come to pass, but we have just had confirmation between me producing these slides actually and talking to you, that that's going to be paused before it comes into effect, and it's going to come in alongside the right to trade unions to carry out e-balloting. So at the moment all ballots are via post. So the thinking behind it in the consultation was that an e-ballot process would encourage more engagement, and so that would naturally increase the turnout, and so they could therefore remove the turnout threshold. And so what we are likely to see in due course is that there will be e-balloting, and then it will need to be passed just by the majority of those in the bargaining unit. If they do have a successful ballot, at the moment there's quite a lot of prescriptive rules about notices that are required. Some of those are changing as well. So at the moment you need to have 14 days notice of strike action. It's being reduced to 10 days notice of the strike action. It's not a very significant change, but it's a compromise from a proposal of 7 days. So it's a reduced notice. And there's also talk that at the moment, once there's a successful ballot, there's a 6-month mandate for that to take effect, and that's going to be extended to 12 months. So there'll be an extension. So it's a 12-month mandate. So there's quite a lot happening to make it easier generally for trade unions to organise and carry out industrial action. This applies to all unions, but unions could also ask to be formally recognised on behalf of some or all of your staff, so perhaps all teaching staff, and that formal recognition is basically giving them rights to negotiate, carry out collective bargaining on behalf of that group of people in relation to their pay, hours and holiday. And at the moment there's a process by which they can formally ask for recognition, and you can either agree voluntarily, or it goes through a process. The Employment Rights Bill says it's going to be easier for them to gain recognition. So as well as having greater rights of access, we're likely to see a continuation in trade unions being recognised, and certainly in the independent school sector. When I first started practicing, there's hardly any recognition, and now it's really, really common, and it's going to get increasingly so, I think. So if your school isn't recognised, be aware of that as a potential. And one option, if you're reticent to agree to recognition by trade unions and what that may do for your culture, is to consider how you have effective two-way communication with your staff at the moment, and make sure that is really working. So thinking about having some sort of staff forum, or if you have one, making sure that that's strong and that's effective, and that it's genuinely a way to share information and listen to the ideas of staff before making decisions. And that may mean that your staff really enjoy and value that two-way direct communication, and are less willing, or there's less of a drive for them to consider being recognised by the unions. So in terms of the next steps, we're also going to see some changes around enforcement, so that are quite important. So at the moment, if an individual has an employment tribunal claim, they largely need to bring that within 3 months. So if they're dismissed, they've got to contact ACAS within 3 months. That limitation period, or that time to act, is being extended in all cases from 3 to 6 months. So that's a bit of a pain, because we all know those cases that we're worried about, but you can normally sort of think, well, when you get to about 4 months, 4.5 months, you're generally safe. But this will be an extended period of time. There's also going to be a new Fair Work Agency. So this is a new public authority that's going to be tasked with enforcing some of these rights of labour market regulation. So they will be able to require employers and to look at, the records for paying holiday in schools. That's a fraught topic, although most of us have got to grips with what that should be now and are paying that. But they will ask for holiday pay records and to demonstrate you are paying holiday pay, and they will also separately be able to bring employment tribunal proceedings on behalf of workers if a worker is reluctant to do so on their own behalf, and then recover the costs of doing that. So actually it'll be interesting to see how much force that Fair Work Agency has, but it is a new initiative to have this sort of public body that can take action against employers. In terms of timing, and when is all of this going to happen? Well, it's still all a bit up in the air, and so many of you will have heard these sorts of updates, and these, news of these really quite far-reaching and fundamental changes, and the reality is we still don't know when they're all going to come into force. So we've seen a round of some consultation and a round of amendments. The government confirmed that they were accepting all the government tabled amendments, and so we've seen that, and the new employment rights bill was published actually just this week. So we've got that. It's going now through the parliamentary reporting stage, so it's actually finished the House of Commons stage now and being published, and it's going up to the House of Lords. Because that's quite a significant piece of legislation, it's 300 pages long. I think there's no doubt that we will see some changes as well as it goes through the Lords. And then following on from that, most of this is a framework for the things that they want to happen. And you'll have been frustrated perhaps with me saying we don't know the detail, but most of the devil will be in the detail, and we will see regulations to implement all these different changes. And a number of others as well. And so we will see those regulations and then a timetable. So what's likely to happen is that between now and primarily October 2026, so about 18 months off, we'll have a timetable of changes. And the most significant ones, I think we'll see some of the trade union changes happening more quickly because they're largely unpicking existing legislation. But things like the day one rights from unfair dismissal, some of the 0-hour worker rights, they are going to be October 2026. So we're still a bit of time off, but it's worth being aware of them and having a little plan in your organisation of the changes that are coming into effect and the types of things you might need to do to implement them effectively. So some will require contractual changes, some will require policy changes, some will perhaps require more management training. You might be looking at the recruitment process, for example. We touched on that. Some of it will be about audit, understanding, who we've got and who might be captured by this. Some of it might be around improving relationships with trade unions. So there might be a whole range of actions. So you're likely to want to put together a plan, which you can keep reviewing as we see developments. And on the slides, which I'll send, we've got a tracker which just covers the different areas of the bill and will help with that. So it's just on our website, so I'm very happy to share that with you all. And that is all that I have to say. I'm sorry, there's an awful lot there, but I hope it was useful, and I'm really happy to take any questions.
Well, thank